Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I have to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I've got to say it, but I've said it now. And we're going to move on because nothing is going to prevent me from giving you an easy to understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. It's crucial that you understand the role of your doctor in your short and long-term disability claim before you stop working and apply for benefits and even appeal a case. I'm going to be talking about four things today. Number one, what do your medical records say, and what isn't in your medical records can make or break your claim from the very beginning. Two, what an attending physician statement form is and how it's used in your disability insurance claim. Three, how the carriers evaluate your claim using disability duration guidelines. And fourth, I'm going to tell you a David versus Goliath story and the story of how one court took on Unum and took them to task for how they handled a fibromyalgia case. Before we get started, let's take a break for a moment. Welcome back to Winning Isn't Easy. Let's talk about how carriers evaluate claims using disability duration guidelines. Now let's get started by talking about restrictions and limitations. Disability carriers want to see that you have restrictions and limitations that impact your ability to do your own occupation or any occupation. Now, rarely are restrictions and limitations defined in a disability policy. Physical restrictions are really restrictions that impact your ability to do things like sit, stand, walk, stoop, bend, lift. Cognitive restrictions and limitations are the kinds of restrictions and limitations that impact your ability to process information, to manage information, to make decisions, to apply that information in different work settings. And then, of course, there are what I call behavioral restrictions and limitations, and they're generally of a psychiatric nature. The question there is, how do you interact with others in the workplace? How do you accept criticism? How do you deal with changes in the workplace tasks that you may be asked to do? Now, oftentimes, disability carriers will review your doctor's forms about your restrictions and limitations and how long they're going to last. And then what they'll do is they will pull out a disability duration guideline. There is a big 2-volume book called Disability Duration Guidelines that, of all people, a psychiatrist compiled in conjunction with other medical providers. And it is almost a disability duration guideline Bible that carriers will use and consult to say, hey, well, you've had a herniated disc and you've had a surgery, and according to this guideline, you should be able to go back to work in 12 weeks. And just because your doctor has given you all these restrictions and limitations, we don't think that those are valid restrictions and limitations because our disability duration guideline says you should be recovered and back to work. Now, obviously that's ridiculous because you are not everybody. Your condition is personal, and how your condition impacts you in terms of your functionality is unique to you. But I want you to understand that disability duration guidelines are just one of the tools in the disability carrier's toolbox that they're going to use to deny your claim or to say that you are no longer disabled based on a rote, raw reading of this disability guideline and without true consideration of your restrictions and limitations. That means that if you are finding yourself in a claims denial situation based on disability duration guidelines, that you may need to undergo some objective testing, like a functional capacity evaluation that objectively measures your physical restrictions and limitations. If you have a condition like fibromyalgia or ME/CFS, you may have to undergo a CPET examination that will document your levels of fatigue after physical activity. If you're having neuropsychological issues, problems with cognition, You may have to undergo neuropsychological testing and repeat brain scans, to document that there is an organic basis for your ongoing problems and your restrictions and limitations. If your claim is being denied because of disability duration guidelines, you really do need an attorney at that point to help you understand not only what the policy says, what the carrier is doing, how they're misusing the disability duration guidelines, and then to formulate and implement a plan to show that the disability duration guidelines are not applicable and that the restrictions and limitations assigned by your doctor are in fact objectively based. Got it? Let's take a break.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. This is my favorite part of the show. I get to talk about David and Goliath and the story of how one court took on Unum to task and took them to task pretty severely in a fibromyalgia case. Now, what normally will happen is in a fibromyalgia case or a case that's hard to diagnose, the treating physicians may be uncertain about the diagnosis, and you may present a treatment challenge. Does that sound familiar? Well, the issue is, can the disability insurance company legitimately deny your claim? As I've said in this entire episode, the disability carrier is going to review your medical records. They're looking for positive findings on physical examination. They're looking for the treatment plan, and they're looking for your response to the treatment. If you lack any persistent physical manifestations of a disabling condition, either in the form of imaging tests like x-rays or MRIs, or there's no demonstrated positive physical exam findings, and your medical condition hasn't responded to treatment, the court's going to uphold a denial of the claim because they, just like the carrier, are looking for positive physical findings on exam. They're looking for objective testing, and they're looking for your response to treatment. And if it all doesn't match up, the judges are more inclined to say, okay, we get why this claim was denied. There's really no objective diagnosis and no objective basis for the restrictions and limitations. However, and it's a big however, conditions like fibromyalgia, ME/CFS are different. Courts have recognized, for example, that fibromyalgia is not a medical condition that can be confirmed by objective testing. And fibromyalgia patients often don't present with objectively alarming signs of their conditions other than their reported symptoms. And it's really well recognized that it's difficult to prove an objective evidence of fibromyalgia. So I'm going to talk about a case called Bormesa versus Unum Life Insurance Company. It's a Middle District of Tennessee case that came out in June of 2021. Now, I like this case, and I use it in my Unum cases and my fibromyalgia cases because there's some good comments by the court. And the court in this case said that they won't mistakenly assume that hard physical diagnostic tools are the only legitimate source for evaluating a patient's fibromyalgia. The court recognized that there were subjective accounts of symptoms that were legitimate sources of information, both from a diagnostic standpoint and from assessing a person's restrictions and limitations. But the court recognized that a patient's claim about symptoms isn't always determinative of a contested medical question because patients can lie, they can exaggerate. They may perceive their symptoms inaccurately, or they may complain of symptoms that are out of proportion for personal or psychological reasons. Now, at the same time, the court recognized that the disability insurance carrier has to present evidence that suggests any other source of diagnostic information would be so comprehensive and reliable that it would negate the self-reported symptoms of fibromyalgia. Now, that's exactly what happened in this case. Unum said, look, we don't think her symptoms are as severe as she claimed. She provided Unum with narrative evidence from her family members and the opinions of her physicians who had a long-standing treatment relationship. Her physicians confirmed that those complaints were consistent with their diagnosis, notwithstanding an unremarkable physical examination. Now, fortunately, the court recognized that an unremarkable physical exam in and of itself is not a sufficient basis to deny a claim. Now, despite Unum's arguments that the lack of objective findings supporting the diagnosis was the basis of their denial, the court said, look, the real issue here is her fibromyalgia disabling? Because we, as the court recognized, there is an objective basis for the diagnosis of fibromyalgia. So let's get to the real issue here, Unum. And the court looked at the accounts from her family members and doctors that confirmed that her symptoms made it effectively impossible for her to reliably work complete days, even in a sedentary position. Now, disability carriers have their own table, if you will, stable of doctors that they use to deny claims. And one of them is Dr. Norris. And Dr. Norris is not a rheumatologist. And Norris was of the opinion that fibromyalgia can never, ever prevent a policyholder from performing sedentary job duties. Now, that is a familiar refrain that I see in fibromyalgia cases. But the court noted that Dr. Norris and Unum did not provide any support for such a conclusion. They found that Norris's conclusory rejection that fibromyalgia was disabling was particularly striking, because Norris says it's never, ever disabling. And we know, as a matter of course, that that's a bit of a ridiculous opinion. Now, specifically in this case, the court noted Borsma's history of professional success, her dedication to her career, and they found that that weighed against any inferences that she would falsify her complaints or exaggerate her symptoms to avoid her career responsibility. In fact, her immediate supervisor for the 3 years prior to her claim for disability submitted an affidavit that advised that she had been dedicated, honest, and a positive attitude. And in fact, her supervisor commented that she wished she had a dozen employees just like Borsma. The court found that she had not gone from having an exemplary, outstanding performance to exaggerating her symptoms so that she could avoid work, but rather fibromyalgia had destroyed her career. And the court recognized, look, I understand there's a struggle with fibromyalgia cases, but in a snarky but telling comment, the court said, diseases and disorders don't always present themselves in a manner that leads to simple disability insurance claims administration. In fact, the judge said that disabilities based on difficult to assess conditions are as common as cases involving disabilities based on easy to assess conditions. So the court said, look, there's no difference between a fibromyalgia case and a herniated lumbar disc case. Carriers and beneficiary providers, administrators, have to approach these situations by applying the applicable plan provisions to the administrative record. And they have to consider the best medical records that are there, even if the understanding of the disease or the progression of the disease or the restrictions and limitations are evolving and incomplete. So I love this case because it recognizes that there are medical conditions that don't have an objective basis for a diagnosis. It swept aside Unum's false evaluation of this case and went to the heart of the matter. And in this case, it was not whether she's correctly diagnosed with fibromyalgia, but whether or not the restrictions and limitations that have been assigned by her doctor are sufficient to result in an award of benefits. And in doing so, the court was impressed by her career record, by the comments of family and friends, and the affidavits of her supervisors, to come to the conclusion that this woman had no reason to exaggerate her symptoms. Her disease destroyed her career. You know that the court reversed Unum's determination and awarded her benefits. And I love it. I hope that you've enjoyed this week's episode. Please, if you like this podcast, consider liking our page, leave a review, and share it with your friends and family. Remember, my podcast comes out every week, so tune in next week for another insightful episode of Winning Isn't Easy.